Hello everybody. Today I am going to discuss about a very important concept of industrial relations which is known as industrial dispute. So first of all, what is an industrial dispute? An industrial dispute is a difference of opinion or conflict between the employer and the employees over one or more issues related to the employment. It means that it can be any issue which are directly or indirectly related with the employment matter. So it can be related to your job security, it can be related to your payment, it can be related with your salary, it can be related with terms of conditions, anything which is directly indirectly concerned with your job or your working relations. What are the features of industrial dispute? There are certain features which we are going to discuss. The one of the important feature of the dispute is that it's a collective dispute. It means that the dispute is not between one individual employee with the management. Rather, it is a group of employees on one side and the management on the other side. Sometimes there may be a group of people representing the management also. So, it is not an industrial individual dispute. Of course, it is an industrial dispute, but it is not an individual dispute. It's a collective dispute. And the dispute may arise out of disagreements between employers and employees over the rules of employment. So whatsoever the rules has been set in the employment conditions, and if there is a dispute between the interpretation of the same or the meaning of the same, there may arise different type of disagreements. It may be related to the conditions of work also, the conditions of work under which the employees work. The industrial dispute may even relate to the non-employment causes of workmen, like if some employees are dismissed or retrenched, or there is a cases of layoff of certain groups of employees. This may also lead to the industrial disputes. And what are the causes of industrial disputes? And one thing is very important. We are using the word industrial disputes, but these disputes has the nature to be, you can say, present everywhere, not only in the factories but in the service sector also. So basically, this is not industrial disputes. This is a dispute between the employer and employee. So, what are the causes? The first and a very important cause of this dispute is demand for wages and financial benefits. Normally, in the developing countries like India and other countries also, not only developing country, developed country also, the most of the time the reason of the dispute or the causes of the dispute are the wages and other matters related to the wages, like timely payment of the wages or the amount of the wages or unauthorized deductions from the wages. Then the another causes are, or another cause is rather, demand for good working conditions. Sometimes the condition of work is not good, and so it becomes very difficult for the workers to survive there. So it may lead to the dispute. Next cause may be that the employee want better employee welfare and social security measures. So in my next lecture or in some of my next lectures, I will be discussing about the concept of employee welfare and social security measures also, because these are very important concepts. But it is sufficient to say here that employee welfare includes such types of benefits which are provided to the employees at the place of work normally, like canteen facility, medical facility, and other type of facilities. And when we talk about social security measures, it is a security provided to employees against certain contingencies of life, like pensions, maternity benefits, provident fund, gratuity, etc. So for those matters also there are certain disputes. And another reason or another cause of industrial disputes is the demand for good human relations, because sometimes the management, they are not in a position to have good relations with the employees, and their government has passed so many laws. So sometimes for implementation of their statutory rights also, the employees go on strike. Then what are the other causes? Demand for justice to an individual or a group of employees. If something wrong has been happened with the employee due to the wrong policy or practices of the management or one person or one group of managerial persons, so that may lead to the industrial disputes. External interference, like sometimes the political parties or trade unions interfere in the internal matter of the organizations, and sometimes they force the trade union to go on strike, workers union to go on strike. And last point is the numerous labor legislation, or many labor legislation. What does it mean? In India, there have been so many labor laws passed by the government, and sometimes their provisions are contradictory. And so for the interpretation of this labor legislation also there are sometimes dispute. And what are the outcomes of dispute, or how we know that the disputes are there? Strike, open strike, when the employee do not work at all, either they do not go to the place of work, or sometimes they go to the place of work but they don't work. Sometimes they do very slow work, and sometimes they go and do only work according to the rule book, not more than that, not less than that. Then there is a concept of picketing. They picket the entire organization. They not allow anybody to come out of the organization or go out of the organization. Then there is the concept of ghirao, where they encircle the office of the HR manager or the director or the higher officials, and they don't allow them to come out or go out of the office. And then there is the concept of lockout. Lockout means that when the employer do not provide any type of work to the workers, when the workers are going to the place of work, that is called lockout. So it is a type of a strike on the part of the employers. So in this case of lockout, there is no closure of the business, but closing the production process for a day, 2 days, 5 days, 10 days, depending upon the nature of the dispute. Now, under the Industrial Disputes Act 1947, there has been a definition given of the strike. So, a strike is a cessation of work by a body of persons employed in any industry acting in combination, or a concerted refusal, or a refusal under a common understanding of any number of persons who are or have been so employed to continue to work or to accept employment. So it means that basically, if you want to say what is the bottom line, the bottom line is that if they are going to work place or not going to the workplace, but if they are not working, and that is a common understanding not to work, and they are and this decision is taken by a group of people, may not be that all employees are on a strike, maybe that a few employees are on strike, but there should be a group of people who are not working, and they are also forcing others not to work. So this is the case of a strike. In case of lockout, lockout is a temporary closing of a place of employment. It means that it is not a closing of business, but it is a closing of a place of employment, or the suspension of the work, temporary suspension of the work, or the refusal by an employer to continue to employ any number of persons employed by him. But the outcome is that the employees go there, but they do not get the job. And sometimes the lockout is done deliberately to test the bargaining power of the workers. And sometimes it is just to force the employees to abide by the dictates of the management. Now the question is that these are the different reflections of industrial disputes. Now what are the ways to settle the industrial dispute? Under the Industrial Disputes Act, there have been certain mechanisms have been set. So I will be discussing very briefly in today's lecture, and I would also explain in detail in my next lecture. So the first step, and which is a statutory step, is the conciliation process. And what is a conciliation? Conciliation is a process to achieve amicable settlement with the assistance of an independent third party. So there is a role of third party. Who is an independent party? Normally he is a government official of the labor department, which is appointed by the government, so that he can do the work of conciliation. So what is the meaning of conciliation? He makes both the parties sit together and reach to an amicable solution. So one thing is very pertinent. Conciliation or conciliation officer is a third party who acts as a facilitator and helps the employer and the employee to reach to an amicable solution of the problem. But he does not make his own suggestions, or he does not dictate upon the terms. He does not force anything. He just wants to make such a situation where both the parties are discussing with each other, and whenever there is any problem, he tries to solve it by providing different type of help, and he tries to facilitate. So basically function as a facilitator. He does not impose anything. He does not directly suggest anything. So normally conciliation should be successful, but in India it is not successful. So conciliation officer, if it is a success, make a report and send to the government, or if it is not successful, still he makes the report and send to the government. In certain cases, there is not a conciliation officer, there is a conciliation board if the government thinks that matter is very serious. But normally, as I said to you, in the case of India, conciliation is not successful. So we go to the next stage, that is arbitration. Arbitration is also a decision by the third party. So arbitration is a mechanism for settlement of a dispute by a third party. And this is also known as voluntary arbitration, because both the party, they select the arbitrator on the basis of their choice and on the basis of this belief that this arbitrator is not a biased person. So he should be the selection of both the parties. And when this arbitration is compulsory, actually arbitration is voluntary basically, but when the arbitration is compulsory, we go to the next level, that is the adjudication. So I am talking about right now about the voluntary arbitration only, because in case of compulsory arbitration it is adjudication and that goes to the court of law. So I will be coming to that in next. But first about voluntary arbitration. In voluntary arbitration, the parties to the dispute voluntarily allow any dispute for arbitration to a third party which is acceptable to both. That is the most important thing, that it should be acceptable to both. Now what is the problem here? When I would be discussing about the trade unions in India, the features of the trade unions in India is that there are so many trade unions, multiplicity of trade unions in one organization. So, if suppose out of 10 unions, 5 unions agrees for arbitration and 5 unions do not agree for arbitration, then at the time of interpretation, it becomes very problematic as to how to solve it, because 5 parties say that we are not going to implement it. They interpret it differently. They say that it is not applicable to us. So ultimately, arbitration also not be successful because some of the parties may not be agreeing. Some of the parties means that employer is agreeing, the employee is agreeing, but certain sections of the employees are not agreeing. So it can never happen that any type of decisions can be imposed upon 5%, 10%, or 20% or 30% people and not on other person. Even if 80% people agree, you cannot impose it upon the 20% people. So arbitration fails. So ultimately, we have to go to the compulsory arbitration, which is also known as adjudication. And what is adjudication? Adjudication is the settlement of disputes by courts or courts of law. So there are different level of courts, labor courts. Then there is the state tribunal, that is called as the industrial tribunal, and then there is the national tribunal. But adjudication is a very time-taking and a complex process. So naturally, it takes so much of time because it's a judicial process. So it's a very complex process. But in one thing important is that its decision is binding upon both parties to dispute. They can't refuse that we are not going to accept it. Both the parties have to accept it. And if they are not going to accept it, they have to be punished. They will be punished rather under the provisions of the Industrial Disputes Act 1947. Adjudication includes labor courts, industrial tribunals, and national tribunals, and it is also known as compulsory arbitration. So, what these labor courts do, what these